Hi there, welcome back. I'm here with Rick. I'm Mallory, and we're here on behalf of Park Chenaur Injury Lawyers talking about point of notice in car accident cases.
Yeah, and this is like a really good issue because it comes up all the time when there's an intersection collision. And oftentimes you get somebody who says the other person was speeding. So even if you're the person who takes a left in front of the other person and the other person's got the right of way, we oftentimes hear the other person was speeding. He was going really fast. So I thought I had enough time to make that left but I didn't because he was going so fast. So what do you think about that?
Yeah, I think it makes sense that we need some legal rules around this, right? Because in that case, each driver thinks that they have made the right choice there. And people speed all the time, right? We don't think of it as a big deal. Like a layperson might not think of this as a big deal. Like people are speeding, going 5, 10, 15 miles over the speed limit all the time. But also, it does impact. Sometimes you can't tell how fast someone's going and you do misjudge that. So I think it's an important thing for the law to make a rule about for people to have some predictability in how these things are handled.
Yeah, and we pulled a couple of different cases. Let's talk about some of those cases. The first case was Tobias v. Rainwater, and that's a case that was decided way back in 1967. Can you tell us a little bit about that case?
Yeah, so in this case, it's that same kind of accident you were just describing, right? Someone's trying to make a left turn into onto a main road, and someone driving on that main road who was allegedly speeding didn't have time to stop by the time that person turned out in front of them. And so in this case, they actually swerved and hit a car on the side of the road. So we know that car wasn't at fault because they were just parked on the side on a side street. But the question is, was the person making the left turn at fault for the accident because they didn't have the right of way? Or was it the person who was speeding because they were going, perhaps, according to the person who made the left turn, driving too fast for them to be noticed by the person making the left turn?
Yeah. And this becomes evidentiary problems because there was a couple witnesses who claimed that they were going 45 miles per hour. They didn't have a speed gun to determine that, and it's very difficult to determine the exact speed. You can determine, like, it just as a layperson, because we've driven as long as we have, that guy looks like they're going too fast, but you can't tell what speed it is, so that becomes a problem.
Yeah, absolutely.
Especially in 1967.
Right.
Now we have accident reconstruction,
Right.
which is somewhat of a science where we can say the length of the skid marks and the impact of the vehicle and where the vehicle ended up. We can reverse engineer and say, okay, they were going 67 miles per hour. And
Yeah,
we've
and all
had that happen. Yeah.
yeah, and all of those pieces of evidence that we have now that they didn't maybe have back then are really important for this doctrine that we're talking about,
Yeah.
because it's all evidence to when should this person, if they were being reasonable, have noticed that there was an accident about to happen and have reacted.
Yeah. So explain that, the point of notice doctrine. Explain that.
Yeah, so the point of notice is basically a way to determine at what point it's for the favored driver, right? On the so the person who had the right of way. Basically, this is an argument that's or a doctrine that's comes up when the unfavored driver, the person taking the left turn in front of them, is claiming they were speeding and so it was their fault, even though they had the right of way. And so the question becomes, at what point should the person who had the right of way have noticed that an accident was about to happen and therefore had a duty to react and take measures to mitigate or avoid that accident, right? And so that's the point of notice, is at what point should they have known the collision was likely to happen and reacted?
Yeah, and then once you determine the point where the favored driver sees that the unfavored driver is gonna not yield the right of way, turn right in front of them, at that point, if the favored driver was not driving at excessive speed, would they have been able to avoid the accident given a little bit of time for reaction time? And that's the real question. So, how what we're trying to figure out is whether or not speed is a cause of the accident or approximate.
Right.
Yeah.
Yeah. So, like, even if they weren't speeding, would the accident have happened anyway? Because if so, then the speed didn't really cause the accident because it would have happened anyway.
Absolutely. And in practice, in real life, this is very difficult to do because, and we've had a case that I know from our own experience that it was very difficult to do where somebody was traveling in a 30 mile per hour zone at potentially 70 miles per hour. So more than double the actual speed limit. And in that case, even then, it was very difficult to prove that speed was the actual cause of the collision. The person who made a left, which was the unfavored driver, he actually had a duty to yield the right of way, but he made a left because he saw the car coming in the distance and thought he had enough time to make the left. But the car was coming so fast, he didn't have time, and a collision occurred. And the analysis there was whether or not the speeding driver going 40 miles per hour over the speed limit at the point that speeding driver noticed that our client was making a left turn, if he was going the speed limit at 30 miles per hour, would he have been able to avoid the collision? And ultimately, the trier of fact said no. And part of the reason for that was the testimony of the speeding driver. And the testimony of the speeding driver was he didn't start to make the left until right before the collision, like a second before the collision. And if you look at where the vehicle would have been a second before the collision, even if he were going 30 miles per hour, the trier of fact thought that the speeder still wouldn't have been able to avoid the collision. So it's a difficult set of facts to win on excessive speed.
Yeah, and
It
you
just yeah.
you
Go
can
ahead.
see where some modern science and modern techniques would be come into in handy in this situation and why it's so important. So determining how fast someone was going and then what that means for where they would have been at the point that the person started making the turn, all of that is like a scientific analysis of based on the evidence that you have, like you said, skid marks and the testimony and the
Yeah.
impact. Yeah.
Yeah, and it requires an accident reconstructionist in today's day and age that you got to pay for an accident reconstructionist to go out there and the timing. So it has to be done right after the collision because the skid marks go away, just
Right.
weather or and time. So you need to get somebody out there immediately and then the cost that it could be a five to $10,000 expert fee to get somebody out there and do the analysis. And you also have to look at the vehicles themselves. And that evidence goes away as well. You can use photographs to some degree. Being able to see the actual video or the vehicles in real life in person is helpful as well for these accident reconstructionists. And then the defense also gets their own accident reconstructionist, and their methods of determining speed are invariably different. That becomes an issue as well. So these cases are difficult.
Yeah, and you can see where there would be a lot of variability because I imagine a lot of this is estimating based on the evidence that we have, which is can be very little, and just
Yeah,
based on testimony. So depending on whose testimony you're relying on and what estimates you're using, you could come up with very different results.
absolutely. So right of way, if you have the right of way, there's a strong presumption, even if the other party was speeding, there's a strong presumption you're going to win on the case. Yeah. There may be some contributory liability, but you still need to get over summary judgment, which sometimes you can't do unless you have that accident reconstruction. Sometimes a witness is not good enough.
Yeah. And actually, the next case we were going to talk about is a good example of how someone with the right of way is favored, but also might be contributorily negligent. So Bonsack v. Kirkham was the next case. This was one where there was one driver who was driving on a main road, and then another driver, the second driver, was coming out, making a left turn from a side road and crossed into the other driver's lane of traffic in order to make that turn. And the driver on the main road, who had the right of way, ended up head-on collision with the other driver as they entered their lane to turn left. And so in this case, the court pretty quickly determined that the person making the left turn was negligent as a matter of law because they didn't yield the right of way. But there was a question of how fast the person on the main road who had the right of way was going and whether their speed contributed to that. So this would be the point of notice argument, right? Was was there a point at which they should have noticed? And at that point, could they have stopped if they were going the speed limit?
Yeah.
And in this case, the court said this is a question for the jury because there's evidence that they might have been speeding, and so the jury needs to determine were they speeding and did that contribute to the cause of the accident.
Yeah, and that's an interesting ruling as well because you can see that it's somewhat speculation just by saying that he could have been speeding or he might have been speeding if there's no solid evidence of how fast was going and at what point at what point the favored driver noticed that the disfavored driver was going to turn in front of him. If there's
Right.
not solid evidence of that, if there was a summary judgment motion, I feel like it would have been dismissed.
Yeah.
Yeah.
But in this case, I think the evidence, there was not much evidence, but there needs to be some evidence in order for it to survive summary judgment. I think in this case,
Yeah.
there was testimony from both drivers, and I think the disfavored driver here did testify they believe this person was speeding. So that alone was enough, I think, for the court to say this is a question for the jury.
Yeah.
And also there were skid marks. And so even though this was 1967, they still did have some sort of analysis based on the skid marks and the impact about that actually happened about how fast they were going. Because
Yeah.
obviously someone coming from a stop is not going that fast. So you can imagine how they would predict the speed of the car based on that. So I think there was enough evidence for it to move forward, at least to the jury in this, the opinion of the court.
Yeah, and the other case that's really good on this is Mendelssohn. So, is that the case with the headlights?
Yes.
Yeah, talk about that case because I think this is a good case.
Yeah, I like this case too. And this one was a little bit later. This was 1980. And so in this case, this was a case where the accident happened at night. And there was discussion of what someone could tell about the person's speed based on their headlights. So these were two cars coming straight at each other, one northbound, one southbound on the same road. And one person was getting ready to take a left turn with someone's headlights coming towards them. And they believed they had enough time to make that turn. So they took the left, and the other person sped and crashed right into them, T-boning them as they took the left turn. So the question was, did the favored driver, right, the one going straight and not taking the left, at what point should they have noticed the accident was going to happen, and did they have time to stop? And there was evidence there that they were speeding. I forget exactly what the evidence was, but I think the police report, somehow the police determined that they were going between
67 and 74,
yeah, something
pretty
over the speed
fast.
limit. Yeah,
Yeah, I
pretty
think the
fast.
speed limit was 35, so
Yeah, and the other
significantly over the
driver
speed limit.
and the driver who was turning left was going like 15 to 20. Significant difference in the speed. And then there was also evidence that the driver who had the right of way was intoxicated. So
That helped.
that contributed to
Yeah.
when they should have reacted. Yeah, but in
And then
Mendelssohn,
yeah,
oh, go ahead.
Mendelssohn, they talk about the deception doctrine, which essentially is that the disfavored driver, when they're looking to make that left turn and they see the headlights in front of them, they think they have enough time
Right.
because at night, when you're just seeing headlights coming at you and you're presuming that this is a 35-mile road, so they wouldn't be going that fast, you would have time to make that left turn. But it's deceptive because it's at night and the headlights are just coming directly at you, so you don't notice all the time how fast the other driver's moving.
Yeah, and Rick, you and I were talking earlier about how there's two different doctrines here, right? The point of notice doctrine, which is mainly for an analysis based on the favored driver's point of view. Then there's this deception argument on behalf of the unfavored driver saying, I was deceived by what I saw happening. One is about the favored driver, were they negligent, even though they had the right of way? And then in this case, in Mendelssohn, the court found they were negligent because they were intoxicated, they were speeding, that did cause the accident. But there was still a question of whether the unfavored driver was contributorily negligent and whether that approximately caused the accident because they still failed to yield the right of way. And so I thought it was interesting. There was this discussion in Mendelssohn that I think is relevant, both for point of notice, but also for this deception argument, that it would have been different, they said, if the evidence just showed that they saw the headlights for a split second from far away and thought, I have plenty of time. That would have been different than what happened here, where they said, actually, there were some dips in the road and they observed the headlights for a few moments before turning. And so they had made a reasonable assumption that this person was going at a safe speed, which they could have assumed based on the evidence. They could have assumed that based on what they saw because they observed them for a few moments. Whereas if they had just observed the headlights for a split second and thought, I have enough time and turned, that might have turned out differently for them. They might have been considered negligent because they do have to yield to the right of way, even if that person is speeding. And so if they don't have enough evidence themselves in that moment to determine the person's speed at all, then they don't have a reasonable inference that they are safe to turn, right? They have to make the reasonable inference that they're not speeding before
Yeah.
they are safe to make that turn.
Yeah, and that's very perceptive of you, which says, like, if a client is in a deposition and they're talking about what they perceived in the accident, and if they did, in fact, make that reasonable determination that the other vehicle was going at a safe speed, and that's why they made the turn, they need to be able to express that in a deposition because if all they say is, "Yeah, I saw that there were the headlights in the distance and I thought I could make that turn," that might not be enough, is what
Correct.
you're saying based on the case. So that's
Yeah,
important to know. So a lawyer who actually has read the case and understands that could have been the difference in the ruling would also be able to talk to their client and say, "What are all the different factors that made you think that you had enough time to turn," and then actually flesh those out so that they
absolutely.
yeah, so they could say them. And the other thing that's, I think, important to note is that when the other vehicle that's speeding and intoxicated, just because they're speeding and intoxicated, clearly those are things that are negligent or unreasonable for a driver to do. But negligence alone is not enough. You also need the proximate cause of the collision piece of it in order for there to be damages that you can be awarded. So negligence
Right,
in itself is not enough. The point of notice goes to causation, whether
right.
or not that negligence was actually the cause of the collision, or whether it was your failure to yield that was the cause of the collision. And in a lot of cases, it's some combination of the two.
Yeah, and I think all of this goes to show how important those favored and unfavored distinctions are, right? It's really hard to overcome that. So even though you can, if you're speeding, you can just because you have the right of way doesn't mean that you're off the hook, right? If you're speeding and you caused the accident because of your speed, that's the point of notice doctrine. You can still be liable. But it's really tough to overcome that presumption that the person with the right of way is the favorite driver. And I think
Yeah,
all
and
of these cases go towards how strong that presumption
yeah,
is.
and you gotta build that case. So, like, you have it's your duty to prove that your failure to yield was not the primary cause of the collision. So, it's
Right.
pretty much presumed that if you failed to yield the right of way, that it's your fault. And in order to show that it was somebody with excessive speed who did in fact have the right of way, that it was their fault, that's a hump that you need to overcome. It's not the other way around.
Yeah.
Yeah. Okay. Awesome. Thank you for talking today about point of notice. I think it's a really important doctrine for everybody who's learning personal injury and doing handling these type of accidents.